Hello, my name is Simeon Gilchrist. I am a solicitor and partner here in the Restructuring and Insolvency team at Edwin Co. Welcome to this third video interview in our Administrations Explained series. In the first interview, I looked at the body shop collapse, and in the second, I looked at some of the basic administration procedures set against the backdrop of the Matches Fashion Group administration. In this interview, I look at recent developments in the Matches Fashion Group administration and the sale of assets by the administrators. And in the next interview, I will look at the administrator's use of stock. First, a reminder of the background. Administrators were appointed to Matches Fashion Limited and to its parent company on 8 March 2024, only 4 months after Matches was acquired by Mike Ashley's Fraser Group in a deal that was reported at the time to have been worth £52 million. At the time, the sale was also reported as a heavy loss for the group's private equity owners, Apax Partners, who had acquired it from Matches founders in only 2017 for a reputed $1 billion. The administrators published their proposals for the administration on 12 April 2024, and they explained there that in addition to buying the issued share capital of the parent company, Fraser Group had also bought Matches senior debt. The proposals describe a payment of £22 million for the shares and the debt, and the provision of a further £11 million of working capital. The £52 million is a figure that doesn't appear in the proposals. The structure of the deal on 20 December 2023 meant that Fraser Group walked into the historic security rights owned by the existing lenders, and that put Fraser Group in a relatively good position in the administration process as a secured lender. Although rescuing a company as a going concern is the first of 3 purposes of administration set out in the legislation, in Matches' case, the stated purpose of this administration was the second legislative purpose, achieving a better result for creditors as a whole than if Matches were simply wound up. Now, the administrators reported that they would continue to trade Matches in administration, hopefully at a profit, and to do that they retained roughly half the staff whilst making the other half redundant more or less immediately. Aside from the employees' preferential claims of about $280,000 that will be paid from realisations by the administrators, the redundancies created roughly £5 million of unsecured creditors right away. The total unsecured creditor pile in April 2024 was reported to have been just short of £36 million. It is now reported by Fraser Group itself that they have acquired from the administrators certain intellectual property assets only. This seems to mean that rescuing the company as a going concern is no longer an option, having been trailed in the proposal, if not actually stated as a purpose of the administration. Clearly, the company's intellectual property has now gone. It is also reported that the deal with Fraser Group allows the administrators to sell the remaining Matches stock for the benefit of the administration. The administrators had estimated in their proposals that there will be a trading surplus of about £15 million. This is interesting. Having bought the intellectual property, Frasers could have interfered in the sale of own-brand Matches stock, but they could also have made an offer for the whole of the stock to sell that through their own retail operations. But they chose to leave the stock with the administrators, meaning that the administrators also have the branded stock that Matches had on its shelves when it went into administration. The creditor schedule is an interesting who's who of luxury brands, and the statement from Fraser Group reminds those brands that the administrators are in possession of that stock. No doubt lawyers for those brands are even now attempting to argue that their client stock should be returned because of retention of title clauses in their supply contracts. I will look at this in my next interview. The press release from Fraser Group does not put a value on the administrator's sale to them of the intellectual property. However, The proceeds are, of course, added to the administrator's other realisations, being £15 million in cash on the day of appointment, an expected £15 million surplus from trading, and whatever else can be salvaged from not selling the company as a going concern. As secured creditors, holding a floating charge over matches undertaking and assets through Sports Direct, Mike Ashley's group can expect a return on their investment significantly in excess of the dividend that is forecast for unsecured creditors. The final costs of the administration are yet to settle, but as described in my first video interview, the other significant deductions from the pot available to repay the secured creditors are the preferential claims of £289,000, the secondary preferential claims of £1.2 million, and the prescribed part. Preferential claims are amounts owed to employees for arrears of wages, holiday pay, and pension contributions. These claims relate to the 256 employees who have been made redundant. Secondary preferential claims are basically taxes, VAT, PAYE, national insurance contributions, and student loans. The prescribed part was introduced as a recognition that the waterfall of money in an administration may be a trickle, or in fact entirely dry by the time it reaches the unsecured cohort. However, the effect of a sliding scale and a cap means that the pot will, at its most, be worth £800,000 if the company's net assets reach just short of £4 million. This appears likely. The proposal mentions unsecured creditors of £36 million. In the unlikely event that this does not rise, this will mean, at most, a payment of 2.3 pence for every pound of debt. I say that it is unlikely that this will not rise because the administrators have still to work out how to handle the 260 or so staff that they retained. Once the trading is finished, and unless the administrators somehow sell on a business with the employees' rights intact, it is most probable that there will be a further massive employee claim to add to the £5 million already recorded, further reducing the dividend to the unsecured cohort through the prescribed part. I will look in further detail at the employee's position in administrations generally in another video interview. Other than the prescribed part, the proposal suggests that it is unlikely that there will be a further payment to any of the unsecured creditors, meaning employees, suppliers and customers will find themselves far short of the return to the secured creditor. Creditors will all be watching with interest. Unfortunately, because the proposals did not anticipate a return to the creditors other than through the prescribed part, watching is more or less all the unsecured creditors can do. The proposals did not ask for a creditors committee to be formed, and the proposals themselves were approved in a deeming process. This is an interesting quirk of the administration process that I looked at in my first interview in this series on administrations. If you would like to discuss any of the issues caused by the matches administration, or should it appear to you that an administration process might be right for you and your business, please contact the restructuring team here at Edwin Co.